This is on indictment 1607-1220, appearances of counsel for the record.
Good morning, Your Honor, or I guess it's good afternoon now. Good afternoon. Cooper Gibbs on behalf of the state.
Brian Chevlin, also for the state, Your Honor.
Good afternoon, may it please the court, Joe Maserani, on behalf of Mr. Puskas is present.
So this matter is before the court following what had previously been a scheduled trial date. We adjourned it now to, I believe it's January 9th. I did send out the court's request for pretrial submissions from all counsel. I have received those submissions. Have you each had opportunities to review what the others submitted?
Yes, Your Honor.
So, with respect to both of your submissions, there really are a number of questions that I think are covered by the standard questions, and others seem to be you're duplicating requests in terms of your requests. So if we could just kind of go through your respective submissions. So the state, in terms of open-ended questions, requested that question A, what are your feelings about drug addiction and substance abuse, followed by have you or family member or close friend ever suffered from addiction and or substance abuse? Please explain, which is kind of similar, Mr. Maserani, in part to what you have asked in your request for question number
I broke them down.
8, and you sort of broke them down. So here's what I would propose to do. There are some of these, I think you're both sort of looking for the same type of information. I would propose to put in the standard questions a question about whether or not have you or family member or any close friend have ever had experience or something to that effect with substance abuse, right? And so that would be posed as a yes or no response. And so if the jurors are giving yes answers to that particular question, then we would be talking to that juror at sidebar anyway. I can also put in the standard questions, the specific question that Mr. Maserani, you're asking about Mr. Puskas specifically, about whether if they were to hear that he used heroin, alcohol, and or cocaine at the time the crime was committed, whether that would have impact on their ability to be fair and impartial. So I will work many of your questions into the standard questions so that if we get yes responses to those questions, many of the follow-up questions that you have outlined are going to be something that we'll be discussing at sidebar. That's how I propose to do that.
If I may address the court, Judge, as it relates to that, I guess one of the things that was on my agenda to talk to you about is the extent to which you're going to allow the state to go into this area. Are they going to put on witness after witness that's going to talk about the debauchery and the heroin use and the cocaine use for days and weeks on end at the house? Or is it going to be limited to certain times and so on and so forth? That's one thing that we're going to have to deal with at some point. I'm not saying we do that today. But I'm reluctant to agree to phrase it as a yes or no question, as long. This is going to be a major issue in the case. I mean, this was never part of the first case. This is going to be a major issue in the case that I think we need to get people talking about. And this is why I really wanted to do this as as an attorney conducting voir dire case, because this is something that I would focus on during attorney conducting voir dire. I'm concerned that jurors are not gonna take the question seriously if it's asked as a yes or no. A lot of people are ashamed to talk about drug use or drug abuse for them, or even for somebody who's in their family or a close friend. So I really want to, and I have no problem working with the court on which way the court wants to do it, but this is an area that requires some delving into. So, and we don't have to decide today, obviously.
I mean, I'm going to have this all ready for you before we obviously start jury selection. But I will tell you that over the years I've incorporated these types of questions into the standard questions, and I've not encountered anyone who, even if when we phrase them as answer yes or no, if they're answering yes to that question, then we're going to be discussing a lot of the concerns that you are raising about the extent to which that it would be something that would affect their ability to be fair and impartial. And I think that was Mr. Shevlin, you can even attest to that. I think we had it in a very recent case where that was not only the victim, someone who's involved in distributing drugs, but also the defendant himself had been addicted, had been using cocaine for a significant period of time. And we had very robust discussions in sidebar when we asked those questions about, the extent to which hearing that type of information is something that will influence their judgment. So I think we can phrase it in a way that kind of gets them talking about it.
As long as you're okay with me, after seeing what you put together, be able to bring this up again. And I don't want to say I agree with you now and not
I'm going to
knowing.
give you how I worked in all of what you're proposing. Some of it we'll talk about where I think that those aren't fair questions, but I'm going to work in what I believe to be what you're trying to get from the jury, and then you tell me whether you think there should be other further changes to it.
Thank you.
So I think the question the state is also asking about the length of time between the commission of the crime and the start of the trial date. That's also something that I could incorporate into the standard questions about whether or not that's something that could sort of pique their curiosity such that they can even focus on the evidence. So I'll rework that so that it's in the standard as well. And then the criminal justice system, whether they believe it's fair, I think that's an appropriate open-ended question. And as you know, I have to ask those two bias questions as part of the open-ended questions. You're squinting. So there's a question about the jurors having heard the video.
Well, they gotta see the video right now.
Yeah, and then you ask them about whether or not there's anything about people's differences and or similarities that would cause them to believe they could. And there's two of them, so those I have to put in the open-ended questions. Also, I think some of what could be incorporated in the standard are your questions, counsel, which are legitimate questions about whether or not they've seen or heard anything about the case in the news or on the internet, whether they've read anything more specifically about Mr. Puskas in the news or on the internet. You also, and I think both of you did this, you referred to the victim here as Billy McCaw. Should we use Billy in parentheses, William in parentheses Billy, because it's really, they're going to hear William McCaw as the victim, I understand. And then, but presumably you know your case better than I do. He's referred to as Billy.
Exactly.
So we can put that in parentheses so that they have both names. And then question about how they feel about defense attorneys, maybe that's something that can go in the open-ended questions so that there can be a discussion about that.
If there needs to be.
If there needs to be. Or it could be phrased as a standard question that would allow them to answer yes or no. Do you have feelings about defense attorneys that you think would cause you to believe you could be fair and impartial? And if they answer yes, then we're talking about it at sidebar. If they answer no, any thoughts one way or the other?
If we're gonna do that, can we have something a little bit more neutral, like on both sides?
Attorneys in general, whether they be state attorneys or defense attorneys.
Judge, the way I've done it before is when I ask that this question be asked, the state gets up and says, well, we want to ask them about prosecutors as well. There's a certain feeling about defense attorneys in general and defendants in the criminal justice system. You know, we do stand with people accused of crimes, and usually, you know, until somebody's accused of a crime, you know, defense attorneys are garbage, right? So I really, if the state wants to ask about prosecuting attorneys, I don't have a problem with that. I do feel that this is something that we should keep kind of separate from the questionnaire. And whether you want to ask it as a yes or no in a separate, you know, when we distill our panel down, when you do the hardships or whatever you do, it's been my experience in the past, Judge, that, you know, once you do the hardships, like, you don't need to ask these questions of people who are going to have hardships and things of that nature, I assume. So we can kind of distill them down and ask that question of less people, I guess.
So the way that I've been doing it, which I found to sort of help move it along some, is to, we would bring up, hopefully the most we're able to get into the courtroom. And by the way, we do have Judge Toto's courtroom, I believe, for jury selection.
We were going to discuss the courtroom situation with you.
See if we could have it the high-tech courtroom, have it for the trial.
You need, okay, so then I will explain that to Judge Toto as well, because I think there are only a couple of courtrooms that have are you looking for the Nomad system, or?
We're looking for more of the technology that's in 201 with the.
So you
It's not
that
201.
that 201 is high-tech.
203 or 204.
High-tech.
I forget.
There's a lot that's not working in there.
Oh,
so
no, it's so high-tech that we are not even.
It's not up to date with the high-tech.
Notwithstanding that, though, and you know, I know every judge loves their courtroom. I think this courtroom is
Oh,
going to be.
we will not be in here. I don't love this courtroom that much, trust me. It's too small. It's just too small.
Okay.
So-
You know, when we did the trial before in Judge Nieves' courtroom, it was bigger than this courtroom, and people were pretty much sitting in the jury's lap.
Yeah.
And I don't think that's
Yeah,
appropriate.
so I mean, I will discuss all of that with the powers that be and endeavor to know where we are for the entirety. Right now, all I've been told is that we will have Judge Toto's courtroom at least for jury selection, but we will not, one thing I will guarantee you, we will not be in this courtroom. So it's gonna be one of the larger courtrooms so that we can accommodate everybody, and if you're telling me that you need the technology as well, then
The Nomad's enough for me, because usually that you could do a lot with.
yeah, you need
I
more
don't
than
know
that.
about what the state.
Your Honor, that would be fine again, it's a start beyond, we've already gotten beyond this courtroom to the states.
Yeah, we're not here, that's not a concern, we're not gonna be in this courtroom. And so, and then, you know, we can talk about like really how long really you think this is gonna take, because, you know, folks get sensitive about their courtrooms, and so if you're talking about a significant period of time and wanting to use one particular courtroom that is assigned to somebody else, then, you know, where I go, that's also bound to have some impact on that. So I'm sure that we can sort of narrow down how long we think this is going to be. And then Mr. Masrani, you also asked about at question number 5 with do do you believe a criminal defendant should testify in their defense even though a criminal defendant has an absolute right to remain silent? I think that's covered in the standard questions already. You phrase it a little bit differently. So
I'm interested in discussing whether people feel like a person, even though they have a right not to testify, they should testify and speak up on their own behalf. I think that's I mean, to me, you could take away the other question and put this one in. Because I want to know how they really feel, even though people have rights not to testify. Again, Judge.
So this is question number 27. So you're saying, let me read question 27. I'm sure you've seen it before, but a defendant in a criminal case has the absolute right to remain silent and has the absolute right not to testify. If a defendant chooses not to testify, the jury is prohibited from drawing negative conclusions from that choice. The defendant is presumed innocent whether he testifies or not, and would you have any difficulty following these principles? So you are asking to replace that question with the one.
I want them both, Judge, because I think this is a different question than that. That explains the right, I think. This says, notwithstanding that right, you think a person who's accused of a crime should testify. So that's what this question asks. It's very different than 27, in my opinion. So I'm requesting that, I mean, if you want to make it part of it, like, add it.
I would be more inclined to perhaps modify 27 to include what you are, what you're asking here is whether or not he should testify, even though
If they feel, right, if they feel that he should. If you want to modify it in a way that would capture that question, I don't have a problem with that.
Thoughts on that one, Lord?
Your Honor, whatever the court is fine with the state's one.
I know we started talking about 4, but I don't think we kind of landed on a plan for 4.
So if you are requesting that I put that in the open, because I think you were saying either way, you don't have, I've rephrased it a little bit differently and said, is there anything about criminal defense attorneys? Do you have any feelings about criminal defense attorneys that you believe will cause you to be unable to hear this case fairly and impartially? And then the state had asked that it be more neutral, and to the extent your request is to sort of keep both of those separate because you believe that people might have opinions about defense attorneys very specifically, then, but I think it's also fair to include the state, so I would just pose 2 questions, one for the state and one
I don't have a problem
for
with that.
and so I'll put that then in the standard questions, one for the defense attorney, one for the state. And then thought 6, you are this again I think is covered in the standard questions, but
It's a little different, right? The difference is we're asking the jury, do they think it's fair that the system places such a high burden on the state? The questions explain the burden of proof and that they have to follow the law and they have to listen to your instructions and so on and so forth. I mean, you can kind of include the idea of this question in that line of questioning, because again, notwithstanding the fact that the burden of proof is beyond a reasonable doubt, some person may feel that's too high of a burden. I'm not gonna hold them to that burden, even though you're telling me to. Some people have ideas that, again, if this was attorney conducted voir dire, would be able to tease that out immediately and very quickly, because you're asking the entire panel that.
So I've seen this type of what you're trying to get at with this question posed as an open-ended question that allows them to talk about how they feel about the state's burden of proof and the burden of proof being proved beyond a reasonable doubt.
Are you, that's fine. I want jurors talking, that's fine with me. But are you saying you're limiting the open-ended questions to just 3, or you're open
So
to having enough questions to get a good jury judgment?
I'm trying to incorporate all the concerns that you're raising, and if it means I can't fit them into what I believe might be a standard question that might get them talking about what you're asking them to talk about, then I can put it in an open-ended.
Thanks, that's fine, that works.
Any thoughts?
So
on that?
I know, I mean, what Your Honor's proposing is I think, probably a better way. The way that this is phrased, do you think it's fair that the law places so high a burden? The burden is defined in the question, and over that burden is defined. And high is kind of an ambiguous term. It is a high burden, but the definition of the burden should be there. I think that's we've done in the other case.
The idea is we're telling them it is a high burden. I mean, it's all over the charge. You're going to define what that burden is. So there's nothing, we're not implying anything here. We're trying to see if the jury has a problem with that burden, or whether they're going to make up their own burden. So
I have asked this type of question. I don't phrase it the way you have, as an open-ended question that defines the burden, and that burden is on the state, and then ask the jurors how they feel about the burden of proof that is placed on the state. And it gets them talking in an open-ended way. If you
then I would ask that you include the word fair. Do you think it's fair that the burden beyond a reasonable doubt is on the state? What I'm trying to get at is a little different than, are you going to follow the law as I give it to you? It's just
which is why I think it can be phrased in an open-ended way about how they feel about the burden, and the fact that that burden is in fact on the state. And at that point, you'll have people saying, well, I think that's what should happen because, a defendant is presumed innocent until the state proves otherwise. I've asked those questions and I've gotten those types of responses. If for some reason the questions I'm asking aren't getting what you think you're trying to get at with their answers, I have no issue with you following up. I will tell you in advance that this is not about getting a jury that either one of you necessarily likes, but rather a jury that's fair and gives each side a fair assessment of the proofs and decides the case based on the evidence, right? And so I will always turn to both sides and ask whether you have follow-up to any questions that I've asked. I say to the lawyers, listen, you can ask your questions directly of the juror, or you could ask me to ask the questions of the juror. However you choose to do it, I leave that up to you. You should know that if you ask the question that I think is not fair, I'm going to interrupt you. And so sometimes people don't want me to do that, and so they'll say, Judge, will you ask the juror the following? I leave that up to you how you want to do it. If you want to ask them directly, I'm fine with that. If you want me to ask it, I'm fine with that as well. But I'll always give you an opportunity if you believe whatever answers you're hearing are really not covering what you're trying to get at. If you have a better way of getting at it, I'm going to allow you to ask those questions.
I appreciate that, Judge. While we're talking about that, never mind, I'll address that another time.
I think number 7 is also one that can be included in the standard as well, whether they've ever witnessed someone violent assault as you characterize it, and with serious injury, and whether or not that's something that would make it difficult for them. I think that we can answer yes or no, and if they have, then we'll be talking about it with them at sidebar. We kind of covered.
The drug questions, yeah.
Nine, I think, is really, there's so many layers to that question. I don't, that's not a question I think is a fair question.
Right, Your Honor, that,
There's just too many layers to that.
As long as you're open to, if it goes down that road, that we can continue to delve with the juror about that, I don't have a problem with that. But if a juror believes that somebody who's addicted to drugs, they're just gonna immediately resort to violence, that's not a juror that can sit on this
I
case.
hear you.
So as long as we're able to dig, no problem.
So if 10 kind of covers what we're getting at in 8. 11, same. I think 12 is okay.
Your Honor, the state's only objection number 12 is when we talk about the MAD and all these other organizations, Crime Stoppers, I mean, to know if someone's a part of that, I guess, the anti-crime workers, what are we looking, I guess, what are we trying to delve in there? Are we trying to look into the fact that these individuals are a part of not having criminal activity in their neighborhood? I mean, what are we getting out of that question?
So I think that maybe this can be like a standard question, and if they answer yes, what?
Yeah, I mean, if it could be asked as a yes or no, because, and what we're getting at here is there are certain people out there that belong to these groups and they're fanatics. So it doesn't matter whether a person is presumed innocent or not, they may not be able to sit on this case. That's what we're getting at.
And that's all I'm saying, to say that someone's a fanatic because they're a part of MAD is a little
But we don't know.
extreme.
So if they answer yes, then we would
We
be
can talk to
asking
them at
that
sidebar.
And I think 13 is that's I think that's a fair question. That asks about whether or not they could look at. Are these indeed? How many photos? Are there a lot of them?
Probably.
Yeah, sure.
We'll try to agree on as many as possible as usual,
Please.
and there are certain ones you'll have to rule on.
And then I think specialized medical training, that's fine as a standard as well. And then do you believe they'd make a good juror is a good open-ended question. 16 is already the standard. 17 as well. And then 18 can also be a standard question.
I know we touched upon the media questions, Judge, if I can go back to that just a little bit. You're aware that there's a lot of media coverage about this case. Our esteemed Mr. Credible from New Brunswick today is here with us today. I assume he's going to be here with us for the trial. There's a 10-year gap, obviously. There's been a trial. There's been a reversal. There's been an appellate opinion that came down between the reversal and now. All of that is out there, Judge. I do think we want to be a little bit more robust with regards to that. I don't believe jurors listen to, don't talk about the case, don't look anything up. You're inevitably going to get somebody who's going to violate that order. And whether they keep it to themselves or not is another story. And even if they don't, you don't know if jurors are going to come to you and say to you, hey, listen, you told us not to do this. but this person did that. So all I'm asking there is to be a bit more robust about this, and not just as far as this case, to ask questions about names like Mr. Puskas or Mr. McCall, and try to get to at least the people who haven't seen all this stuff, because there's a lot of stuff in the media that's not admissible in a trial, whether it's this case or another case. I had a situation in the past where the media was excluded from the trial because they were reporting on things that were being objected to during the trial. The judge was keeping them out, and the reporter was writing about them in an article every day. The judge excluded this evidence. It's you know, so the point is, things that happen here should you know, stay here as much as possible, because jurors should not be looking at this stuff. Which brings me to something that that has been a practice of many judges that I've been in front of in the past. When we have a panel, when we have our jury, judges in the past, not a couple times in this county, but a lot of times in Union County, Essex County, and Hudson County, when jurors go in the room, they collect the phones. It asks the jurors to turn the phones off, and they collect them. The sheriff's officers collect them in a box when they're in the room, whether deliberating or not. And then when they leave the room to go on break and so on and so forth, they can take their phones back. I'm going to be asking you to do that in this case. I think it's a good idea, and it kind of will show the jurors that, listen, this is a serious thing. We're taking your phones, not to punish you, but you need to focus on this case. You can't be looking at things on your phone, whether it's about this case or not. So I'm going to be asking that you do that here. It's effective.
Do you have any thoughts one way or the other?
As far as taking phone?
Yeah.
No.
In terms of your statement of the case, it seems pretty. Any objections to the state's proposal?
I don't have a problem with it. Which one are you looking at? This?
Yeah.
No, that has more stuff on it.
This is the right one. That's the, I think that was the one. Original?
It should have been the defendant denies the allegation.
Yeah.
Yes.
This one doesn't get started.
The only issue I have here are, well, two issues. It should be that the state alleges. I have a problem with the word submit. And I would ask that where it says the defendant denies these allegations, that you include our wordage, which I put in the letter. This is what I asked for during the last trial. This is kind of, I worked off the thing from the last trial.
Your Honor, as far as that sense, the state has no problem with Mr. Puskas denies the state's allegations. However, to say what the defendant asserts, the reality is, obviously, if Mr. Puskas wants to testify and assert he can understand, he can, but we're not going to put out information that at no point during the time in question did he see, what he touched, what he interacted with, or what he struck involving the decedent, unless, of course, he wanted to take the stand. So we look at this as almost a statement of Mr. Puskas, and we would be objecting to that. We do not object to denying the allegations.
So I-
Judge, that's our position. I mean, that's the position that's gonna be taken during the trial. Doesn't, it's, if you want to word it in a way that's, sounds less like a statement, we're entitled to put our position out there just like they're entitled to put their position out there. So. If you want to take some time to think about it.
Yeah, I mean, I think a denial of each and every one of the allegations as set forth by the state is sufficient, and I'll leave you to make those statements, opening remarks to the jury to the extent that that's the position you're taking. The
Okay.
evidence will show, of course, that
Because I don't know if you want to continue, it's 12:45. It's up to you, I don't care.
let's go to like one. Yeah, that's true.
We'll be on. I'm okay, I'm fine, I'm fine.
Sure?
Yeah.
Maybe another 15 minutes of school.
That's fine, Judge.
And then, so I've witnessed this.
I think those witness lists are not ready yet, let's put it that way.
And Your Honor, before we get to the witness list, I do know we went through the defense counsel's numbers. I would just want to address the record in regards to the indictment. I know that the indictment as it stands right now, Your Honor, has 4 counts. Count 1, the top count being murder, and 2 and 3 being the weapons offenses. But count 4 of 1607-1220 is a hindering apprehension and prosecution. And at this time, Your Honor, the state is looking to dismiss count 4 and proceed to trial on counts 1, 2, 3. So I wanted to place that on the record since the state has outlined that in their letter to the court to make sure that the record is clear as we begin to go through the final charges, violent charges. Thank you.
And you don't have your stipulations at this time?
Your Honor, there are no stipulations at this time.
We haven't, it's kind of a little early. I suggested a stipulation about some of the testimony that the state wants to have come in through the decedent's mom and dad. Well, those are kind of more substantive and weight issues. We can deal with those when we have more time. I don't want to get into arguments about that.
And Your Honor, I would though, if we believe that there are going to be arguments in regard to that, I would want that to be heard, if not today, for us to set aside a date well before January 9th. Raised in the state's point 6, after a review of the trial transcript from the first trial, it seems to be a record-breaking number of 104 hearings that occurred during that trial, almost related to each witness. And at this point, in order to not have that occur again, and to give a realistic expectation to the jury about how long we are going to try the case, the state would ask if counsel believes there are any motions, as you just mentioned, for us to come back in 2 weeks, for us to come back before we start picking that jury and have people here each day to conduct these hearings, which can become rather lengthy. Even looking at today, we just went over a pretrial motion. They can become lengthy, and we do not want to waste anyone's time, especially the jury's time.
Judge, there's nothing about this case that's going to be short. There are a lot of landmines in this case. And there's going to be a lot of hearsay that I feel there's going to be a lot of landmines. And I endeavor to deal with a lot of these issues with the state. That's why I suggested in my email to the state, maybe we can stipulate to some of these things. I have concerns about, mom and dad testifying about losing their kid. Obviously, they're not going to testify, oh, we feel bad we lost our kid. That's not going to come in. But there's certain impression or perception that comes in when mom and dad testify in a murder trial where their kid was killed. So I'm trying to avoid problems as much as possible. And I'll work with the state as much as they want to work with me about these things. So, I mean, I'll do what I can. But I can't file motions on things that I don't know are going to be a problem. So, you know, I mean, sometimes sometimes it's an objection. Most of the time it's an objection. If there are issues that need to be dealt with, bring it to your attention. I mean, I have no problem sitting with the state and going over this stuff.
Well, Your Honor, just in response to that, just so that I'm clear, Mr. McCall testified at the first trial. So there's really nothing to litigate or go through with that. It was fully litigated at the first trial. He testified as to the Hamilton Street address that the victim resided at a certain point, as well as his sister residing on Hamilton Street. So that's been litigated. I believe what counsel is specifically referring to is, and that's not going to be stipulated to, Your Honor, as it was not in the first trial. Mrs. McCall, what has come up an issue that we've gone through with prior motions is the fact that it is alleged that Billy somehow was involved with people doing nefarious activities like distributing a part of drugs or some kind of drug dealing. That was what was alleged. However, we have the bank records from William McCall where his mother was a custodian of records and would transfer him $40, $50 every week, showing that he did not usually have a balance that was anything close to anyone who, bringing the assumption that they were dealing in narcotics would have. It was a bank account that she controlled and that she had with him that showed really the fact that he had to ask his mother for $40 to $50, $20 here and there to be able to survive as a college student during that time. So that's why it's relevant to bring her in to testify to that, especially in light of that particular motion that we had, Your Honor, in September.
Mrs. McCall is not the custodian of records from the Bank of America. She's the account holder. She cannot authenticate and introduce bank records. She can testify that she would send her son money, sure. But if somebody's gonna authenticate the bank records, that needs to be somebody from Bank of America. Again, I don't want to get into this and waste your time today with all these things. I'll try to work with the state on these issues. I think you understand, I hope you understand what my concerns are with Mom and Dad testifying. Dad's testimony the last time was something that we went over a lot because we wanted to avoid problems with certain perceptions in front of the jury, because sympathy has no business in this trial.
I mean, to the extent that the two of you are looking, or the three of you are looking at a transcript of a prior trial, it seems to me that you understand where, as you characterize it, the landmines are, right? Where there were objections, and where perhaps those objections might have been sustained, whether they were overruled. And with that in mind, it seems to me that you all can talk about what you agree upon is can come in, and those things that you say shouldn't come in, we should be dealing with ahead of time, to the extent that you cannot agree as to whether they come in or not, right?
I agree, Judge. And again, just because certain rulings were made in the first trial doesn't mean because how the case is coming in, an objection may reverse or may not be sustained or may not be an objection. Not every objection, that whether sustained or overruled, is the law of the case. I hope that's not what the state's saying.
No, I mean, I get that, because at the end of the day, I anticipate that this case may come in differently just based on the fact that there's a lot of evidence that's no longer a part of this case. So how you try your case is how you try your case, and I'm not Judge Gambis, and so I can make my own decisions about whether or not I think evidence is admissible or not. There may have been stuff that he said no to that I'll say yes to. There may have been stuff that he said yes to, I'll say no to. I don't, you know, I'm not being held to whatever happened before, because I think that your case is going to look potentially very different. Right?
And I'll work with the state as much as they want, Judge. I don't have a problem with that.
So
As far as the witness list is concerned, it's not, I wouldn't say it's ready today, Judge, because there are people that are not on there that should be on there. If you're looking for a witness list that to read to the jury or to give to the jury with the questionnaire, I would say to you, don't even waste your time looking at that today. That's what I would say.
So get it to me as soon as because I like to get it all ready beforehand so that they have it to go with the questionnaire.
Do you agree?
Yes, correct, John, that's perfectly fine, I will definitely send something over to you before the new year, absolutely.
And then, just scheduling wise, I would like to try this case Monday through, I would like to do it Monday through Friday if I had my druthers, but Monday through Thursday.
Full day Thursday, right?
Yes. And then.
And if you want to try 5 days, I don't have a problem.
I would love to, just to get it in and be done.
I don't have a problem with that.
So we're gonna figure out how we can work that out, but at a minimum, it'll be Monday through Thursday, at a minimum. But I'm gonna shoot for Monday through Friday.
Yes.
So with that in mind, what can we say is our anticipated?
That depends.
You're saying
It depends.
We need to be telling the jury something.
Well,
It depends on-
it's going to depend on a few things. If we're able to work out a lot of the stuff,
Give me the worst case scenario.
I can't.
What's the
Worst case scenario is 8 weeks. I don't know.
So I'm gonna tell this jury 8 weeks.
Yeah, I mean, I don't know. You know.
We can't say 4 weeks and then they're here 8, but we can say 8 and they're only here 4, right? Or we can say 10 and they're only here.
I would love to do this in the shortest amount of time possible.
So would I.
So, you know, one thing that can delay us, for example, is I know some prosecutors don't like to tell you the day before who they're calling the next day, right? I don't know if these prosecutors are going to do that. If they are going to do that, at some point I'm going to make an application to you, just like I've done with other judges, to order them to tell me who they're going to call the next day, so I can pull everything I need to be ready to just pull it out of a box here. This is a 4-drawer file cabinet, 4 foot wide. I can't bring that file cabinet with me to court every day. It's 10 banker boxes. So, what would make this go smoothly is if I know the day before. I'm not asking you to tell me a week before, just the day before the end of the day. This is who I'm calling tomorrow, so I'll go to my office after the day's over, pick everything I need, and bring it to court, so I don't need to ask you for a break between direct and cross, so I can go collect the file. That would make things go very smoothly, but that's up to the state. And then ultimately, it's up to you under 611, Judge. You can say, no, you have to let them know. And for both of us, like I have to let them know too if I'm calling witnesses, obviously, who I'm calling the next day. So, you know, that's one issue that may come up. It's been my experience that in this county, this is what we do. This is what the state does. I hope it's not the case, but with this trial. There may be other issues, and I promise you that I'll try
I
to do.
have to tell the jury something.
I agree.
8
And
weeks.
Judge, and this is why the state is suggesting to do some of these 104 hearings before then. The state obviously put 3 weeks for their case. If counsel is saying, 8 weeks, you're talking about 8 weeks, that's a very long time, but if we believe that that's gonna take 8 weeks, we could tell them that. I'd rather overshoot than undershoot. I don't have a problem with that, Your Honor, that's all.
8 weeks. 2012, note taking, blanket.
It's a long time, which I
I
hope
would
that we can
object to any
use.
note taking.
Yeah, I don't like it. Sidebar, you're okay with him?
Yeah.
And then-
Speaking of sidebars, man, look right myself. Will it be okay, like when we're doing sidebar with jurors, to have a table where we can all sit down around it, or do we stand the whole time?
I'm gonna see whether, because
If we have the room, you know?
Yeah, so if we're doing it in Judge Toto's courtroom, there's actually a jury room like attached. And
Yeah,
so
okay, so you
may
do it in
be-
there? Yeah.
Yeah.
Thank you.
stuff marked beforehand, if you're gonna use it, if you think you're gonna use it, if you're imagining you're gonna use it, just mark it. I'd rather have it marked and not used than to have to mark throughout the trial. It's kind of annoying. Close.
I'll take care of that. I would just ask that there be an order that he be allowed, he can get a haircut, and shave, but I'll take care of clothes. That's not a problem. I mean, should it be in the order that they accept the clothes at the jail? I don't know.
I think they're okay with that. I think it's the shoes that you should bring here, and he can change his shoes once he gets here.
Sometimes they'll take shoes there depending on the shoes, and
It's been touch and go with the shoes, so.
I'll do what I need to do, Judge. You don't have to, unless I have a problem,
Okay.
you know, you don't have to worry about that.
I think that's pretty much it for now. All right, we are scheduled then to have the jury hear the video on Monday, so jury selection will start on Tuesday. If there are issues that need to be addressed before, we would have Monday available. If the jurors are looking at the video, I'll have a calendar obviously that day, but I'm available if need be. And if there's something that comes up even before then that you think requires the court's attention, you'll let us know. We'll figure out how to bring it in. Otherwise, we'll see you on the 9th, and then